welcome you. Today, we're doing a deep dive into something pretty essential, legal research. Think of this as, well, your guide to how legal knowledge gets built and found, now in the 21st century.
Yeah, and we're drawing on some core texts here. Things like legal research, materials and methods, how to do research, stuff like that.
Right, and guidelines from universities, government bodies, too. Our mission, really, is to unpack what legal research actually involves today, the methods, the key ideas.
And it's probably worth saying, right off the bat, there's been a bit of a shift in legal academia.
Oh, yeah. How so?
Well, you see more career academics, and they're increasingly competing for research funding.
Okay, so that pushes standards up.
Exactly. It means, more rigorous research criteria, higher qualifications needed. It changes the game a little.
So when we talk legal research, then, what's the fundamental task? What are people doing?
At its heart, it's really a cycle. You start by locating the primary law, legislation, case law.
But are raw materials?
Precisely. Then you analyze it, you synthesize it, pull it together, and then, importantly, you critique it. It's not just finding stuff, it's engaging deeply.
Okay, let's dig into that. It sounds like legal research isn't just, dusty books anymore. Our sources say it's getting more interdisciplinary.
Oh, absolutely. Pulling in ideas from other fields, definitely. And multi-jurisdictional, too. You can't just stay in your own little legal bubble.
Right. And what about the academics doing this research? What's expected of them now?
Well, it's interesting. It's not just enough to be scholarly anymore. There's a real push to show your research is systematic, original.
And useful.
And contributes to society's well-being, yeah. It's about establishing quality, credibility, research with impact, not just, for its own sake.
But even with all these new approaches, it seems like doctrinal methodology, that core legal analysis, is still central. Why is that?
Well, think about it from a practical lawyer's perspective. At the end of the day, they need to find the law, understand it, apply it.
Right. Client problems.
Exactly.
Yeah.
And doctrinal research, focusing on statutes, precedents, that gives you the fundamental toolkit. It's kind of the bedrock.
Okay, that makes sense. Now let's zoom out a bit. International law seems like it's really weaving its way into Australian law now.
Definitely. It highlights how interconnected legal systems are becoming. The sources give some great examples, like the Nick Toonen case.
Oh, right, the Tasmanian case. Remind me, how did international law play in there?
So Toonen took his complaint about Tasmania's anti-homosexuality laws to the UN Human Rights Committee, an international body.
And that actually had an effect back here.
It did. It ultimately led the federal government to pass the Human Rights Sexual Conduct Act in '94, basically overriding the state law because of that international finding.
Wow. So direct impact from an international committee.
A very clear example, yeah.
And not the only one, I take it.
Not at all. Think about the UN Convention on the Rights of the Child. Australia signed it, but it's not all directly written into our law.
But we still have obligations.
We do. We have to report to the UN. And the UN committee kept raising concerns about Queensland, for example, treating 17-year-olds as adults in the justice system, unlike other states.
So even without being fully legislated, it creates pressure, like a standard to measure against.
Exactly like that. It exerts influence on policy.
And does it seep into correct decisions too, the common law?
It does. Those international values get considered. The Mabo decision, on native title, it referred to the Racial Discrimination Act, which itself came from an international convention.
Right.
And then there's the Teo case. That established this idea of legitimate expectation that government actions should align with treaties we've ratified. So yeah, these values kind of permeate the system.
Fascinating how it all connects. Okay, so moving beyond just finding the law, context seems really important. Our sources stress that.
Absolutely critical. You can't just look at a law in isolation. You need the history, the policy behind it. Why was it enacted?
Like its origin story.
Kind of, yeah. What was going on socially, politically? Knowing a rule started as, say, a wartime measure totally changes how you might interpret it today. It's the why behind the what's.
And this links into theory, doesn't it? The idea that all research has some kind of theoretical base.
Pretty much, yeah. Whether it's explicit legal theory or ideas from sociology, economics, whatever.
Yeah.
There's always a lens.
A way of seeing the problem.
Exactly. And that lens shapes your questions, your methods. You need to be aware of it, even if it's subconscious sometimes. It's the framework for your whole investigation.
Right. Okay. Now, something fundamental. Ethics. Huge in any research. What are the key things in legal research ethics?
Well, the big ones are protecting human participants, obviously. Animal welfare is relevant. Environmental protection.
There are codes for this, right?
Yes, the Australian Code for the Responsible Conduct of Research is the main one. It lays out the principles.
And what counts as misconduct? Like, what are the big no-nos?
The code spells it out. Fabrication, making up data. Falsification, messing with data or processes. Plagiarism, passing off others' work as yours.
The classics.
Yeah. Plus things like serious breaches of protocol or covering up someone else's misconduct. It's pretty comprehensive.
It's funny, our sources mention Charles Babbage back in the 1830s noticing similar stuff.
Isn't that something? Yeah, he talked about hoaxing, forging, trimming, cooking data. Different words, same basic problem.
So issues of research integrity aren't exactly new.
Not at all. The temptations have always been there, it seems.
Okay, let's shift gears to the practicalities. Doing the research. How do you keep track of it all?
Oh, organization is key. You absolutely need to record your process, what steps you've done, what's left.
Like a log.
Yeah, and dating searches, dating documents you find. A research diary is highly recommended for anything substantial.
What goes in the diary? Just dates and searches.
It can be much more. It's a space for reflection,
Yeah.
jotting down ideas, those aha moments, maybe mind maps.
Capturing the thinking process.
Exactly. And justifying your decisions. Why did I follow this path? Why did I abandon that one? How did my focus change? It's invaluable when you look back.
I can see that. And managing the materials themselves, especially now, everything's digital.
Crucial. You need a consistent naming system for files. Think about future use. Could this help another project?
Good point.
And backups. Seriously. Automatic software, external drives, cloud storage. Use multiple methods. Losing digital research. Nightmare scenario.
Definitely want to avoid that. Okay, so let's talk methods. We mentioned doctrinal research earlier. Can we unpack the techniques?
Sure. So doctrinal is finding, analyzing, synthesizing legislation and case law to reach a conclusion. The IRAC model is a common framework.
IRAC.
Issue, rule, application, conclusion. You might see variations like IPAC or Isaac's, but the idea is structured legal analysis.
A step-by-step approach. What tools help with that?
Checklists are great for routine stuff, like updating case histories or finding all cases on a specific section.
Streamlining things.
Yeah. And legal encyclopedias, even digital ones, are still super valuable. They give you curated, categorized summaries, a great starting point.
Like an organized overview.
Exactly. Then you dive deeper.
And the synthesis part, what does that involve?
That's where the real analysis comes in. It's not just summarizing. It's critical conceptual analysis, understanding precedent, statutory interpretation, legal reasoning methods.
Weaving it all together.
Precisely. Understanding how different bits of law interact to form a coherent picture on a specific issue.
Requires some deep thinking. But legal research isn't only doctrinal, right?
No way. There's theoretical research, often drawing on philosophy, great for highlighting inconsistencies, inequalities.
Like feminist theory or critical race theory.
Exactly. Or economic analysis of law. They provide different lenses to critique the law, expose biases or inefficiencies.
Understanding the values underneath. And what about research within government?
Yeah, that's usually public policy research, done inside departments to develop or evaluate policies, driven by government needs, usually.
Okay. And then there are bodies like the Australian Law Reform Commission, law reform research.
Right. Their whole purpose is finding areas of law needing change. They're known for being really consultative, putting out discussion papers, asking for public input.
Ag-free, open process.
Very. And interestingly, they're quite effective.
Yeah.
A high percentage of their recommendations actually get implemented, lead to real legal change.
That's impressive. Suggests their approach works. Now, we absolutely have to talk about electronic research. It's changed everything, hasn't it?
Well, completely. A paradigm shift. Think back to the 80s, early 90s. Electronic databases were expensive, limited. LexisNexis, Creel, Scale.
Specialist tools.
Exactly. Now, vastly more accessible. So many online resources. And crucially, free public access to case law. Judgments via places like AustLI. That's revolutionary.
Democratizing legal information in a way.
Yeah.
But with all this info, how do you navigate it effectively, these databases?
Understanding their structure helps. LexisNexis has jurisdictional libraries, then material type date. AustLI lets you browse by jurisdiction or database.
And search terms? Any tricks?
Well, know about stop words, common words the database might ignore. Understand Boolean operators, AND, or, not T, and use quotation marks for exact phrases, especially if they contain stop words or Boolean terms.
Learning the search engine's language, what if you're not sure what words to use?
Brainstorm. The cartwheel of terms idea is good. Just jot down every related keyword you can think of. Synonyms, alternative spellings, judgment versus judgment, regional terms.
Testing a wide net first.
Exactly. Especially in full-text databases. You need to think broadly about the language used.
And what's field or segment searching?
That lets you target specific parts of a document. Like search only the case name or the judge's name or the catchword.
Narrows things down.
Significantly. Westlaw, LexisNexis, OSOLexi all have different fields you can search within. Much more precise.
And those positional operators, W/something.
Yeah, like WSHAG within a hashtag words, or PRE preceded by hashtag words, and LexisNexis, or just near and others. They let you say how close your search terms need to be.
More control.
Definitely. Always check the database help guide, though, to see exactly how they define near or whatever operator they use.
Mastering these tools seems non-negotiable now. Okay, another shift. Engaging with social science research. That feels like bridging different worlds.
It can be, yeah. Lawyers and social scientists often have different starting points, different philosophies. Empirical analysis, observation, hypotheses, patterns, and data is central for social scientists.
Whereas lawyers are more text and precedent focused.
Traditionally, yes, though that's changing. But empiricism often builds on previous studies, generates testable questions. It's a different rhythm sometimes.
And lawyers can be a bit skeptical of social science. Why is that?
Sometimes, yeah. Maybe feeling it's less definitive, more open to interpretation. The old lies, damn lies, and statistics idea.
Right.
There can be a perception that findings depend on the methods used or the researcher's view. And lawyers are trained to be critical analyzers of evidence, so they apply that lens.
Fair enough. But understanding their methods is useful. Can you give us a quick rundown? Quantitative versus qualitative.
Sure. So quantitative is about measurement, numbers, using stats to find patterns, test hypotheses. Surveys are a classic example. Structured questions, large numbers, statistical analysis.
Crunching the numbers.
Pretty much. Whereas qualitative is more about understanding meaning, context, getting the why behind the what.
How do you do that?
Interviews are key. In-depth conversations to get rich perspectives. Then you transcribe, analyze the text for themes, verify, report it narratively, depth over breadth often.
Getting detailed stories. And what about action research?
Action research is interesting. It's about solving practical problems in a setting, not just studying it, but working with people to make changes and see what happens.
Very hands-on.
Very. And collaborative. It aims for positive change, often focused on things like justice or equity. It can use both quant and qual methods, too.
Sounds really practical. Okay, another area, comparative legal research. Looking at other countries' laws.
Yeah, really valuable. See different ways to tackle similar problems, identify best practices, maybe inform our own law reform.
But you have to be careful who you compare with.
Absolutely. You need to compare like with like, ideally. Systems with similar legal traditions, similar stages of economic, political development. Comparing Australia and Canada makes more sense than, say, Australia and a country with a totally different system in history.
Finding meaningful parallels. And what's the difference between comparison and benchmarking?
Good question. Comparison is often more academic, theoretical, understanding differences and similarities in legal concepts.
Whereas benchmarking
Is more practical, performance-focused, measuring your system against others on specific metrics, like how fast are commercial disputes resolved. Comparison is understanding, benchmarking is measuring performance.
Got it. Theory versus practice, almost. Now, briefly, citation analysis. Sounds like counting footnotes.
Well, sort of. It measures the impact of publications by seeing how often they're cited by others. It's become more important because of things like ERA excellence in research for Australia, which uses citations as an indicator of research quality.
So it affects academic rankings and funding?
It can, yeah. Journal rankings based on impact factor are a bigger deal now.
Okay. And one more method. Triangulation. What's that?
Triangulation is basically using multiple methods or data sources to study the same question.
Why do that?
To cross-check findings. Make your conclusions stronger, more reliable. If interviews, surveys, and doctrinal analysis all point the same way, you've got a much stronger case. It mitigates the weaknesses of any single method.
Building a stronger foundation from different angles makes sense. Okay, let's rewind to the very start. Formulating a research topic, planning seems crucial.
Oh, absolutely essential. Good research needs planning on two levels. First, the idea plan, topic, aspect, hypothesis, maybe arguments.
What?
All right. And second, the research plan, the methodology, how you'll actually investigate it. How. And it's not static. It evolves.
A living plan. How do you come up with the actual question, though?
Heuristics guiding questions can help, like Aristotle's 5 basics. What is it? What's it like, unlike, cause, effect, what's been said? Good starting points.
That being the topic.
Yeah. And brainstorming, obviously. Asking what if, exploring different angles, helps you narrow down from a broad area to a specific, answerable question.
And visual tools. Mind maps.
Super helpful. Mind maps let you see connections between ideas. Fishbone diagrams, Venn diagrams, they help structure your thoughts, identify key themes visually.
Seeing the whole picture, our sources also mention Horrigan's project analysis matrix.
Yeah, that's a neat framework. It pushes you to think about a legal issue on multiple levels, like the current law, the theory behind it, the social context, reform possibilities, deeper theoretical understanding.
Expanding your thinking.
Exactly. Yeah. You probably wouldn't cover all of it in one project, but it helps you see the different dimensions and potential research paths.
Okay, so you got a rough topic. Refining it, writing a proposal. What's key here?
Getting the right supervisor is huge. Someone with expertise in your area, knows the field. They're your guide.
Your mentor.
Definitely. And nailing down that research question, making it really specific and focused, maybe developing a testable hypothesis.
Yeah.
Your initial argument or hunch.
Something you can actually investigate.
Right. And the proposal needs a clear research plan, structure, methods, resources, timeline, maybe even a budget if needed.
The roadmap again?
Yeah. And for deeper research, a conceptual framework is important. That's the theoretical lens you'll use for collecting and analyzing data. It situates your work.
Provides the why for your approach. Okay, before you start your own digging, you need to review the literature, more than just reading.
Yeah. Critical reading. Active, thoughtful engagement, evaluating arguments, checking evidence, considering counter-arguments, but also seeing the strengths.
Assessing reliability, relevance.
Sufficiency, validity, all of it.
How do you do that practically?
Summarize in your own words. Question assumptions, logic. Connect it to other things you've read. Analyze the methods. Evaluate the overall contribution.
And legal materials have shortcuts. Head notes.
Absolutely. Headnotes, catchwords, and law reports, they're concise pointers to the key points. Huge time savers.
So what comes out of all this critical reading?
Your literature review, essentially.
Yeah.
An annotated bibliography is often the first step, list of sources with summaries and critical notes.
Building your foundation.
Yeah. And thinking about specifics like, for treaties, are they part of domestic law? How are they enforced? For articles, what's the author's expertise? How rigorous was their method?
Got it. And a good literature review
is focused on your question. It analyzes relationships between sources, identifies themes, debates. It's not just a list of summaries. It shows, the field and where your work fits.
Sets the stage for your own contribution. Finally, legal writing itself. It has a reputation.
Huh. Yeah, it says. Often seen as complex, jargon-filled, maybe even exclusionary.
Creates barriers.
It can. Precision is important, obviously, but clarity should be the main goal. Avoid needless jargon. Explain necessary terms. Think about your audience.
Balancing act. And expectations change depending on the level. Essay versus PhD.
Big time. An essay shows understanding. A PhD needs a substantial original contribution to knowledge.
High bar. What about abstracts?
Crucial. It's a concise summary. The problem, methods, results, conclusion. It's the first impression, so it needs to be clear, accurate, compelling.
Your research elevator pitch. Any practical writing tips?
Start early. Even just notes. Break the project down. Don't aim for perfection first draft. Just get it down.
Yeah.
Then revise. Edit for clarity, logic, grammar.
Get someone else to read it.
Definitely helpful. Even a non-expert can spot unclear arguments. And of course, meticulous referencing. Use a guide like the Australian Guide to Legal Citation. Absolutely vital.
Non-negotiable in law. Wow. Okay, so bringing it all together, our sources really map out the landscape of legal research resources.
They really do.
Yeah.
It's comprehensive. Dictionaries, encyclopedias, databases like OSISLine, LexisNexis, Westlaw, treaty collections, government sites.
Categorized by type and jurisdiction, too.
Yep. Australia, UK, US, Canada, EU, NZ, India, China, plus practical checklists for finding specific things like legislation or cases in different places. A really useful toolkit.
So from the big ideas to the nuts and bolts, this deep dive shows legal research is, well, pretty complex and dynamic.
Absolutely. It's constantly evolving. You need the core skills, but also adaptability, ongoing learning. The landscape keeps changing.
Well, hopefully understanding these foundations as you've laid them out helps empower you, our listener, to navigate it all, whether for work or just curiosity.
And maybe a final thought to leave people with. Just consider how this massive increase in online access to legal information is continuing to transform legal research and what that means for society more broadly.
A lot to think about there. Thanks for unpacking all that.
My pleasure.